So I want to start with a story. Terry and I live right behind the Supreme Court, and on the day that they announced that Ruth Bader Ginsburg had passed away, we walked down to just see what was going on, and there was a lot of reverence, but there was a lot of tension, and it didn't take long before some of the people that were there to pay their respects started shouting political slogans, and there was a lot of emotion, but it almost seemed more religious than sort of respect for a woman who had done fantastic things and lived an incredible life. And it dawned on me at that moment that somehow, somewhere in America, the Supreme Court has gotten way too powerful that the passing away of a single justice, 1 out of 9, could create this sort of existential crisis for at least half America. And that strikes me as a good starting off point to talk about your new book. I don't know if you planned it this way, but your new book, Supreme Disorder, Judicial Nominations and the Politics of America's Highest Court, is a great sort of historic primer on how we got where we are today. And I'm hoping that you can solve all of our problems.
Yeah, the hagiography that we have surrounding justices really makes it surreal. And you're right. A lot of the problems we have is because the court has become too important, and each justice, therefore, because there's only 9, has become too important. And to give everything away right up front, what's different about the way that politics affects the confirmation nomination process, because it's always affected it to some extent. I mean, the president, going back to George Washington, is a politician. Senators are politicians. What's different, and we'll discuss all that. But what's different now is you have centralization of power in Washington, and a skewing of that power towards the administrative state. So the Supreme Court is ruling on all these major political controversies, and divergence of interpretive theories that map onto partisan preferences at a time when the parties themselves are more ideologically sorted than they've been since at least the Civil War. So yeah, each one of these precious seats, and we saw the inverse 4 years ago with Scalia, that this is what happens. It's a tremendously fraught battle. And of course, I guess when it's a progressive justice, you also have, supporters are less religious, and so this is the closest thing to a saint or pope that they have.
Yeah, it seemed like a civic religion, and all the iconography of black robes, and like they're almost like the high priests of deciding truth in the United States. So as a libertarian, it sort of makes me incredibly uncomfortable that someone chosen for life would have that sort of power over my life. But that's how we've gotten here, and you sort of document that. And let's start. I'm not going to follow a logical progression here because that would require too much discipline on my part. But what do you think the tipping point was, particularly in terms of judicial philosophy, that the Supreme Court became the deciders? They're more than an equal branch of government in a lot of ways.
Yeah, you can tell different tales. You can use different inflection points. In my book, which like Gaul is divided in 3 parts. So you have the past, the history, basically George Washington through 1968, which is my answer to your question. The second half is the present, basically the last 50 years, 68 to now. Then the third part is the future, potential reforms and things like that. But I picked 1968, especially, and you're right to touch upon judicial philosophy. It's not, when did we start having cataclysmic battles? Well, we've sort of had them throughout different times in our past. Even George Washington had a nominee rejected. Probably the biggest battle over any nominee was, I'd say, in 1916 with Louis Brandeis. Another presidential election year. But 1968, when LBJ, right, was a self-anointed lame duck, decided he wouldn't run for re-election, unpopular due to Vietnam, civil unrest, and Earl Warren, the controversial Chief Justice, presided over desegregation, civil rights revolution in various ways, criminal procedure, all sorts of things that led to the term liberal judicial activism, and had bumper stickers and billboards impeach Earl Warren. He announced his retirement, and LBJ tried to elevate Justice Abe Fortas, who wasn't just a justice, but was a close confidant of his. I mean, was advising him on where to bomb in Southeast Asia, among other things. And Fortas ran into a buzzsaw, a bipartisan buzzsaw, I should say, about various ethical concerns, financial things he hadn't declared, plus the cronyism with LBJ. And some people call it the first filibuster of a Supreme Court nominee, but he'd never even had majority support in the Senate. And again, the opposition was bipartisan. But really, it's at that point with Nixon running on, no, I will fill the activist Warren seat with a strict constructionist. And it's really at that point that I'll point to where judicial philosophy took off, rather than one particular issue, be it trust busting or slavery or the formation of the republic or what have you. But judicial philosophy writ large, and the divergence of the parties on that, really 50 years is where I'd peg it.
And just prior to that, you tell the story of Byron White and JFK's appointment of him, and how White was actually sitting at the hearing doodling, because it was very much a formality. There was no expectation that the Senate would reject the president's choice. Was that more normal before '68?
Yeah, and doodling and chain smoking. The hearing, which took place 8 days after he was nominated and lasted all of an hour and a half, of which he himself, the nominee Byron White, testified for about 15 minutes, largely about his football career. Certainly the last justice we'll have who played a professional sport in the NFL, led the NFL in rushing for that matter, while in law school. Remarkable man. The hearings, I mean, first of all, hearings didn't start until that tumultuous year of 1916 that I mentioned, because it was controversial that Brandeis was not only Jewish, but a big progressive crusader, although Brandeis himself did not testify because that was seen as unseemly for the nominee to present himself. But hearings didn't become a regular thing until the 50s. Some nominees before then appeared before the Senate, some didn't. But it became a regular thing in the 50s because Southern Democrats wanted to grill them on their views on Brown v. Board of Education and other civil rights issues. With White, that didn't become so much of an issue or a problem. But yeah, his sort of hearing, which was kind of perfunctory, maybe a couple of hard questions from a random Southern senator, but that was about it. And then it was when the hearings became televised and the Democrats went after Robert Bork in '87 that it really turned into what we would recognize now as the modern confirmation process, and certainly the modern hearing style.
Yeah, it strikes me that the borking of Robert Bork, and you point out that is now a verb that very much applies to the Supreme Court nomination process. But that does seem to be a change, at least in the politicization of the process, and maybe they were performing for the cameras. Of course, now ostensibly President-elect Joe Biden played a part in that, and you talk about the Biden rule, which we'll get into. But there was that moment where Robert Bork, they threw everything in the kitchen sink at him to try to politically destroy him, and successfully did that. And it seems like at that moment the gloves came off on both sides. Is that fair, or is that an exaggeration?
Well, it certainly came off on the Democrat side. The Reagan White House was not expecting it. I mean, they were on their back foot. Their strategy was to paint Bork as neither a liberal nor a conservative, just like the justice he was nominated to replace, Lewis Powell, one of the swing votes for a long time. And that Bork just called them as he saw them, that he was not an ideologue, almost defying reality in a sense, trying to make him into just I have no views on anything. Although the way that he testified is now kind of exhibit A of what not to do, in the sense that he actually answered in depth all of the senators' questions. I mean, it was a tour de force in terms of you could learn a whole first year, even upper year law school constitutional law class just from his 5 days of testimony. And he was also being an academic. He was fighting with the senators. He was making sure they understood the nuance of every scholarly point he was making. Paul Simon, senator from Illinois, Democrat, who was on the committee, would write in a book that he published right after the Thomas hearing, obviously the next contentious one, that Bork might have squeezed through the committee had the vote been taken before he testified. But he did himself no favors and was interested in making academic points, debaters' points, rather than gaining votes. And so since then, we know the playbook, and Justice Ginsburg probably kind of patented it, really set it out straight, that you try to talk a lot without saying very much. No hints, no previews, not even getting into philosophy, because judges should deal in specifics, but can't get into specifics because that might come before me. So the Bork hearings were unique, not because he was rejected. Nixon, after all, had 2 nominees rejected, but there wasn't this spectacle or this kind of demagogic attack of the same sort, and that's why Bork is really the beginning of the modern, I guess, ratcheting up of tensions and the tit-for-tat escalations between the parties.
You say that the Republicans were kind of caught flat-footed because the rules changed before their eyes, but it strikes me that happened again with Clarence Thomas and what he would eventually call a high-tech lynching. It was sort of a personalized character attack on him that I don't think was normal prior to that.
Yeah, with Bork, it was kind of twisting his words and making it seem that under his philosophy, we would go back to Jim Crow. We would have mass censorship. The parade of horribles that Senator Ted Kennedy announced on the floor of the Senate 45 minutes after the nomination of Bork. With Thomas, a little bit different. Biden played an even bigger role. He was chairman both for the Bork and the Thomas hearings, but he really led the Thomas hearings, whereas Kennedy and certain others were played a kind of a higher profile role with Bork. And they didn't really lay a finger on Thomas during the first part of the hearing. It's only when Anita Hill came out, parallels to what happened with Brett Kavanaugh more recently, that it was this kind of personal attack. And Biden said at the time that he tried to play it straight and ended up pleasing no one. Some of the liberals in his party thought that he wasn't strong enough on Thomas. And of course, conservatives haven't trusted him since then.
And fast forward to Gorsuch, one of the points you make in the book that I hadn't really considered, but the all-out war that the Democrats declared on Gorsuch and really didn't succeed in landing a punch, and then they went nuclear, the so-called nuclear option. That was an overplaying of their hand that very much handicapped them when it came to trying to do the same thing to Kavanaugh.
Right. I don't think that Lindsey Graham, let alone Susan Collins, would have gone along with the nuclear option, getting rid of the filibuster to only require 50 votes to 50 plus 1 to approve a nominee, to replace Anthony Kennedy, the middle vote, the swing vote, with Brett Kavanaugh. But they didn't face that dilemma because, as you say, the Democrats went too strong against Gorsuch. And I think Schumer, then as now the Senate leader for the Democrats, the minority leader, I think he knew all of this calculus, but he was between a rock and a hard place. There were activists picketing outside his brownstone in Brooklyn. They wanted blood after the blocking of Merrick Garland in 2016. They wanted every possible weapon thrown at Gorsuch. And even though he knew very well, Schumer did, that McConnell would finish what Harry Reid started in getting rid of the filibuster for lower court nominees, he was ducked into that corner. And so with Kavanaugh and now with Amy Coney Barrett, the Democrats really, they had no tools in the arsenal. In fact, and Nancy Pelosi, obviously, in the House, when she was interviewed right after Barrett was nominated, she said, well, there are plenty of arrows in our quiver. And she was talking about maybe impeaching someone to slow down the confirmation, although that would have been instantly dismissed in the Senate as well. So there really weren't any arrows in the quiver after Mitch McConnell forced by the Democrats to go thermonuclear, as it were, and remove that filibuster barrier. Although, Thomas was only confirmed 52-48. Alito was confirmed 58-42. So they never reached that 60-vote threshold. But the filibuster wasn't really something that was thought of. And that shows how there's further and further escalation over the last 30 years since Bork.
Who brought the filibuster to the table? I'm struggling with my history here. I know that Harry Reid very much sort of opened this can of worms of eliminating supermajority votes. But who started the fight?
After Bush v. Gore, remember when the left considered it that the Supreme Court selected Bush rather than him being elected. Um, there was a lot of bitterness, a lot of outrage among legal elites on the left. And it was at a retreat early in 2001 where Cass Sunstein, former regulatory czar, my former professor at the University of Chicago, he's now at Harvard, and Lawrence Tribe, longstanding Harvard professor, came out with this strategy that you meaning Democratic senators, should filibuster Bush's illegitimate lower court nominees, and that's where it went. From Bush's first, I think it was in May of 2001, where Bush had his first slate of 10 or 11 lower court nominees, and most of those ended up being filibustered, most notably Miguel Estrada, who eventually withdrew his name after failing 7 cloture motions, attempts to break the filibuster, because as we learned from leaked documents, the Democrats didn't want him to be in a position to be elevated as the first Latino justice. Although some dispute about that. Benjamin Cardoso was from Sephardic Jewish extraction in Portugal, so depending on your definition of Hispanic, he might have already been that. But that was where the politicking starts. So 2003 with Estrada and Harry Reid, and 10 years later, of course, it was Harry Reid who got rid of the filibuster for lower court judges.
It's interesting that the claim that Bush was an illegitimate president started this fight, and we're as we speak, and by next week when we run this show, maybe there is a declared winner in the 2020 presidential election. But a lot of people a lot of Democrats are eviscerating Donald Trump for not sort of quietly going away and challenging the legitimacy of some of the votes. What's your take on all that? Does Trump have a right to go through this process and make sure that votes in Pennsylvania and Michigan and all these states are legal and proper? Does he have any tools to approach that?
Well, he has a right to file whatever cases he thinks are appropriate in different states. What we're learning from all this, from this go to the mattresses strategy, is that there's really not any evidence, or at least not sufficient, to overturn margins of tens of thousands of votes. I mean, in Michigan, it's over 100,000. You don't change those by finding a box of missing ballots or doing a recount. I mean, that is significant and structural and much greater than anything that Rudy Giuliani can come up with off the top of his head in a hearing. And so, I don't necessarily begrudge Trump's legal team in filing cases in different ways or calling for a recount in, say, Wisconsin or Georgia, where it is very close, about 10,000. Although, recount can get you several hundred votes. It's not going to get you 10,000. What is, I think, damaging is Trump insisting still that he won, and if he didn't, it's only because of massive fraud. Again, without presenting that sort of evidence. This is not Bush v. Gore, where it came down to 500 votes in one state. It's not even Bush v. Gore times 5 or 6 states, because again, the margins are not in the hundreds of votes. So some of the talk and sort of leading his supporters increasingly to think of the eventual result as illegitimate, I think that is that's not good. Although let's be clear that the Democrats don't have clean hands either. 4 years ago, the resistance sprung up, and Hillary Clinton, didn't concede, and she conceded formally, but then kept talking about the problems in the process. And Stacey Abrams, right, also I think still considers herself the governor in exile of Georgia.
Yeah.
So there's plenty of ill feelings and soiling our democracy to go around. I think if the shoe were on the other foot, with Trump leading by 30, 40, 50,000 votes in half a dozen states, and there would be litigation as well from the Democrats. It would look a slightly different perhaps, but When you have bitter polarization politically and a low level of social trust with low public confidence in our institutions, this is what you're going to get. And I don't know the way out of it, but certainly part of the impetus for my book is that the Supreme Court has been swept up into the same toxic cloud.
And it's like both parties for the past 4 years. I mean, forget Al Gore in 2000, but I feel like a lot of the left has called Donald Trump an illegitimate president for the last 4 years. And by the way, I'm not a huge Trump fan, but I find these tactics to be sort of mutually assured destruction, where no matter what happened in this election, whatever party had succeeded in taking the White House, the other party had built this narrative that whatever happens, it's illegitimate, and it's dangerous, and it's fraught with political hypocrisy, and taking just one step back, remembering the so-called Biden rule. Explain what the Biden rule is, and explain why nobody means it when they invoke the Biden rule, because it really depends on whose guy is up on the block.
Right. In June of 1992. Senator and still Senate Judiciary Committee Chairman Joe Biden gave a speech on the floor saying that if there's a Supreme Court vacancy before the election, that George H.W. Bush should refrain from making a nomination, and the Senate would not take that person up because it would be a detriment to the country in all sorts of ways. Of course, there was no vacancy at that year, and Clinton won the election and got 2 vacancies the 2 next years. But that was obviously brought up again in 2016 when Antonin Scalia died in February of that election year, and President Obama a month later in March did make that nomination of Merrick Garland, and the Senate, Mitch McConnell said right away, without waiting for the eventual nomination, that there would be no hearings, there would be no votes, playing hardball. So, and at that point, it came out that the Biden rule, and also the Schumer corollary, or a reaffirmation of the Biden rule in, I think this was in 2000. This was July 2007, more than a year before the 2008 election, that George W. Bush should not get any more opportunities to fill Supreme Court seats. So, as you said, hypocrisy to go around, when historically it really comes down to whether the Senate is controlled by the same party as the White House or not. In presidential election years, let me back up. Overall in our history, when the Senate and the White House are controlled by the same party, the confirmation rate for Supreme Court nominees is about 90%. When it's different parties, it's south of 60%. And in presidential election years, it's still 90% if it's united government, but it's 20% if it's divided government. So knowing nothing about 2016, knowing nothing about 2020, forgetting the Biden rule or anything else, just going by that, you would expect to have happened what happened in 2016 with no confirmation, and in 2020 with a confirmation. So, people change positions based on what's politically expedient. Surprise, surprise, senators flip-flop.
But of course, both parties are somewhat boxed in by the activist base that they've helped create, that expects them to do by any means necessary whatever it takes to stop the other party. And the thing that came out of all of the bitterness, Trump was able to nominate successfully 3 new members of the Supreme Court, and progressives went bananas about that. And that's where this narrative came from, that, well, we'll just take the White House and pack the Supreme Court. Can Joe Biden pack the Supreme Court?
Well, it doesn't take a constitutional amendment. The Constitution is silent about the size of the Supreme Court, and we've had as few as 5 and as many as 10 in our history, with changes always coming with, not just for pure reasons of the country's growing, we need more justices, but also for political shenanigans, preventing the power of the Federalists or the Democratic Republicans, or we can't let Andrew Johnson fill any seats because he's illegitimate, and all these different reasons in the past. And so it's been fixed at 9 since 1869. All it would take to change it would be an act of Congress signed by the president. Of course, there's still a filibuster for legislation in the Senate, so it would take the nuclear option, or whatever kind of weapon they come up with analogy to define what getting rid of the legislative filibuster would be. It looks like that option is now dead on arrival because, of course, at best, the Democrats would be split. The Senate would be split 50-50 with Kamala Harris providing the deciding vote. And I've been told by people who are expert in Senate parliamentary procedures that the president of the Senate, meaning the vice president in this scenario, Harris, does not get to vote on to be a tiebreaker on procedural motions. And so there's no way at this point to break the legislative filibuster, even if Joe Manchin, who said that he would not be for getting rid of the filibuster, let alone packing the court, went back on that. So I think we're safe for at least 2 years from any of that talk, which is why it's quieted down. A month ago, I was doing interviews, and every single time it was all about court packing. Now, it doesn't look realistic at all. Biden did say that he wants to have a bipartisan or independent judicial reform commission. We'll see if that happens or if anything comes of it. Frequently, these blue ribbon commissions are just to, kind of put an issue on the back burner, and then, that's very nice. We'll file this report in the circular file, and nothing happens to it until there's more political power to do what I actually want to do.
It strikes me that those calls were probably never taken all that seriously by Democrats behind closed doors, but I bet you it did really well in direct mail leading up to the election. And a sort of shameless demagoguery. Trump is arguably guilty of the same thing by suggesting to his most ardent supporters that this election there was broad, massive fraud. There's no evidence that that's true yet, and we'll see. But this idea that we're going to pack the Supreme Court was sort of an empty political gesture. Do you think?
Well, I mean, if the Democrats had won several seats, and had a comfortable margin where, the 50th Democratic vote would be not Joe Manchin, but someone a little more solid or a little more, not a swing senator, as it were, then it would have become a realistic possibility. I mean, there's other things I suppose they could have done. They could have packed the lower courts. They still might do that, add more judgeships, which we haven't had new judgeships in, I think, 30 years, or maybe there were a few created under Bush, but it's, there are a lot of district courts. I mean, not very political, but just like the bread and butter of federal judging that are overworked. And so they could do things like that still. But I think this court packing issue inured to the benefit of Republicans. I mean, this is probably one of the reasons why the Republican Party overperformed both in the Senate and in the House, as they saw this crazy talk of court packing and whatever else, the Green New Deal, getting rid of the filibuster, we'll do all this stuff, the socialism and all that didn't help Trump, or it helped him somewhat, not enough, to have those winning margins, but to do better than the polling was showing. But it certainly did preserve the divided government, and indeed, Joe Biden will be the first incoming Democratic president without Democratic control, unified control of Congress since Grover Cleveland, I think, in 1888, something like that. So, no coattails, no sales. I mean, this is all going to be very negotiated. We could see for the first time since Thomas a confirmation hearing process during a time of divided government.
So in the abstract, I mean, put aside the fact that it would be Biden and presumably it would be progressive activist judges that he would nominate, do constitutional scholars that believe in limited government have a opinion about the optimal amount of Supremes on the court?
Well, I take this up in my book. If I were writing on a blank slate, designing a new constitution or a new Supreme Court, you might want more than 9. Say if you had 19, there would presumably be fewer 10-9 decisions than 5-4. Each one of those 19 would be, less powerful than each one of 9, so that would diffuse tensions. Perhaps there are some dynamics, the management consultants will tell you about the decision making in larger groups, but I don't think 19 is, or 15 or whatever is so big that really the system breaks down. So maybe you'd have more. The problem is we're not writing on a blank slate. And so how do you get from what we have now to whatever some platonic mean might be? And even if you said that, well, this doesn't take effect for 10 years, well, there's nothing stopping that Congress 8 years from now seeing the writing on the wall from changing it back or growing it further. So I don't think there's an optimal number that way. Term limits might help turn down the heat a little bit, at least if it would prevent these morbid health watches over octogenarian justices or politically timed retirements, and you'd have the regularity. Each presidential term would have two during election years. That when you're voting for president, for Senate, that you're going to get two in the next 4 years. But we have to be clear that would not change the ideological balance of the court. It wouldn't change its power and the significance of its rulings. And that's why, I'm amenable to term limits. But to really, change the dynamic and these big fights that we have, it has to be more substantive, more about the product than the process. All of these reform proposals, whether with twiddling with the number, the term limits, how you ask questions of them, all these different things are rearranging deck chairs on the Titanic. And the Titanic is the ship of state. That is, we've had a decades-long progression of federalization of power, and within the federal government, a skewing of power away from the legislative branch. Congress punts its power, lets the executive, let the administrative agencies write all the rules by which we actually live our lives, and that makes the court ever more important. And so unwinding that, enforcing federalism, separation of powers, making the court less important, not totally unimportant. It would still have to decide individual rights issues. Abortion wouldn't go away, guns, all these sort of, the culture war stuff wouldn't go away, but at least you wouldn't have the Obamacare type cases. Texas wants this kind of environmental regulation, California wants another. Why is Washington making that decision for everyone at the same times? But that's ultimately the dynamic that we have. That, or kind of a reshuffling of the parties so that judicial philosophies don't neatly match up to political ideologies.
Yeah, it strikes me that reforms of the court are really treating symptoms and not problems, and you can go all the way.
Exactly right.
Go all the way back to George W. Bush signing campaign finance legislation, and I believe at the time saying, "I know this is unconstitutional, but I'm going to do it anyway."
Yeah, he's basically admitting that he violated the oath that he took. Absolutely.
Yeah. And that cavalier attitude is let's just let the court take care of it. And I think conservatives and certainly libertarians put a lot of stock in the Supreme Court challenge of Obamacare, only to discover that Roberts really was going to make a political decision and not a judicial one in that case.
I think I've spilled plenty of ink and plenty of tears over Roberts' decision in NFIB versus Sebelius, that first Obamacare case 8 years ago. But the irony here is that in doing what he did, thinking that he needed to uphold Obamacare, to punt it back to the political process in that 2012 election year to decide the health care law's future, and thinking about the court's legitimacy, he really decreased in the public's eyes the court's legitimacy in that way. It would have been one thing if Anthony Kennedy had simply agreed with the liberals and say, yeah, there are no limiting principles on what the federal government can do. At that point, it becomes a political battle. What kind of judges do you want? Do you want originalism and textualism, or do you want this free-ranging, there's no constitutional limit to federal power kind of theory? Instead, because, as you said, he made a small p political decision, Roberts really told the people, look, I'm not going to uphold the Constitution. If you want that sort of thing, you need to find your own strong man. It's not in the law, and so they did. I think that decision contributed to our populist moment.
Yeah, and I'd like his rationale was to protect the court, but I feel like he's made it now ground zero in every philosophical and ideological battle that we have moving forward. And another, so I picked on George W. Bush, so let me pick on Joe Biden for a second. His campaign made it very clear that one of the first things that they would do should they take office is pass a national mandate that people would have to wear masks. Is that constitutional?
No. The federal government does not have a general, what's called police power to regulate for health and safety. There are certain statutes, the Defense Production Act we heard about in the early pandemic about, updating contracts to get more ventilators made and more PPE and things like that. There are certain, control of the CDC and things that are federal programs. Federal government could have shut down airports and interstate highways, for that matter, things that actually are under the purview of the federal government. But a mask mandate is not that, which is why when we had the lockdowns or shelter-in-place orders, essential businesses versus non-essential, all of that stuff, that came from governors and mayors because states do have police powers for the general health and safety. So I think what Biden or some of his advisors or those in the media who talk about a national mask mandate, it's largely shorthand for trying to convince and cajole the governors to put in the mandates. Now, there are some sticks, if a governor decides not to do it, could the president withhold certain funds that go towards, say, COVID recovery, that go towards vaccines, or enforce limits on interstate commerce, interstate transportation, isolate the particular state. Literally, nobody can go in and out. Those kinds of extreme measures might be possible to try to coerce a state to take it. But at the end of the day, I haven't even seen, the most radical left-wing legal person, I don't mean activist, but professor or something, argue that there is a direct power to order a mask mandate by Joe Biden or a shutdown or something like that.
Yeah, there's a lot of power, as you were alluding to sort of bully governors and cities into submission. Because when the Surgeon General and the CDC and NIH and the government's health advisors are all saying that if you don't do this, people will die, you can imagine the political implications. And we're seeing this sort of demagoguery now.
And by the way, I mentioned withholding funds. NFIB, that Obamacare case, the undercard issue below the individual mandate was transformation of regulations having to conditioning existing Medicaid funding on agreeing to expand Medicaid under Obamacare. That was struck down by a 7-2 vote. And so one thing that Joe Biden will not be able to do is say, hey, put in these mandates or you're not going to get your transportation funds. You're not going to get your education funds. You're not going to get your Medicaid funds, because that under that NFIB precedent would be unconstitutionally coercive. So at least there are some limits there.
Yeah. I mean, the demagoguery itself seems to be working right now. Politically, it appears to be easier for governors and mayors to sort of fall in line, even if they don't want to, just so they don't get blamed for someone getting sick. And it's a dilemma that I'm still scratching my head about. But I want to ask you, like you mentioned that the states have tremendous amount of power when it comes to COVID lockdowns and mask mandates and things like that. And I live in the District of Columbia. Before she locked down the district, much like a number of other blue states did at the time, I didn't even know what her name was. She didn't ostensibly matter that much to my daily life as a resident of the District of Columbia. And at the time, I thought to myself, is it possible that a mayor has the power to call up the National Guard to police stay-at-home orders, which is something she certainly talked about doing. Do individual rights matter in a pandemic, or do these governors have a blank slate?
They do. Cato's actually put out a lot of papers on this. So we have a new department or a new kind of area of research called Pandemics and Policy. And so I wrote the one about police powers, which does touch on individual rights claims both under federal and state constitutions. And there's a lot of leeway. There especially was a lot of leeway in the early days of the pandemic when we didn't know the epidemiology, we didn't know very much. Now it's kind of a sliding scale. The calculus is different. It's not a blank check. It's not, in a hurricane, you can evacuate people, force evacuation from the coast. In a pandemic, you can't evacuate people from the coast because that has nothing to do with anything. Similarly, in a pandemic, you can, enforce social distancing or masks or something like that, but you can't say, I don't know, you can never go outside your home or something like that. Things have to be reasonable. Things have to pass the smell test, and they also have to be applied equally. So There are a lot of restrictions on gun stores, for example, that were invalidated because the same types of shopping or practices or regulations were allowed for, well, even for liquor stores, let alone grocery stores. And there you have, there's an equal protection issue before you even get to assertions of fundamental rights. Similarly, there should not be a problem with drive-in churches. If you just drive to a parking lot and you want to pray communally in your own car, that's very different than all being indoors with no air circulation. So judges have, there's a lot of deference, but there's limits to what the courts will allow.
So perhaps most recently, the governor of Michigan, Whitmer, was knocked down a peg by the Michigan Supreme Court on this question of whether or not she had this sort of broad-based power. And they told her she didn't, and then she proceeded to do it anyway. What does that even mean?
I'm not familiar with the very latest development out of Michigan. I know in some states, I know in Wisconsin, the state Supreme Court threw out, this was a couple of months ago now, the entirety of the lockdown because it was done by some health department deputy official who didn't have, under the state's own administrative powers, the authority to do that. And so they're enforcing their own state laws and state constitutional separation of powers issues. I think similar things were happening in Michigan, where the legislature, I think, had to authorize her to take more powers or something like that. But there is that, just because we're in a crisis or a serious situation doesn't mean that we're in an emergency, right? When you have cancer, that's very serious, but you don't get it treated at the ER typically. So similarly with emergency powers, lockdown powers, that sort of thing. We're into month 8, or is it 9, of the pandemic. Legislatures can and should act if they want to. If they don't, under many states' constitutions, the governor can't just say that, well, I'm creating a new, granting myself more powers out of thin air.
So when Senator Mike Lee was on the show, we spent a significant amount of time sort of pointing back to the legislature, and I think the same thing would be true at the state legislature level. You sort of scratch your head and you wonder who sort of defends the Constitution when the court won't do it and the executive branch is sort of running rampant, doing all sorts of at least extra constitutional things. And it strikes me that the burden always falls back on the legislature to rein that in through the power of the purse. I assume that even Whitmer can't do whatever she wants if it's defunded. I'm hoping that there's some sort of way to rein this in.
Yeah, I mean, there's a vicious cycle where everyone defers. It's like 2 or even 3 wolves arguing with the sheep about what's for dinner. If the courts, this is part of the dynamic that's affecting Supreme Court battles, because if the courts are allowing Congress, and the same dynamic happens at the state level, to just delegate all of its powers to the executive branch because they don't want to bear the political accountability for certain unpopular things that happen. If the courts aren't there to say, no, you are not allowed to delegate your legislative power to anyone, executive branch or otherwise, that is your power. And what James Madison and the other framers of our separation of powers structure failed to anticipate was the party system, whereby rather than jealously guarding their legislative prerogative, Congress or state legislatures are happy to punt that responsibility, either just because, as I said, that way the bureaucrats get blamed when they put in regulations that are unpopular or hurt people, or because they're from the same party as the governor or the president, and so they're not going to oppose that executive branch when it aligns with their ideological views.
Yeah, but quite contrary to their pledge to defend and protect the Constitution, it's typical for partisans, Republicans and Democrats, to simply say, I'm siding with my president. He's my president. He calls the shots. And that's very contrary to how this whole separation of powers of things was supposed to work out.
Absolutely, which is why it's doubly infuriating when the courts, getting one of these legal challenges to that kind of dynamic, say, no, we're just going to defer to the political branches. They must have considered their constitutional duties, and it's a close call. We'll just defer to their evaluation of the legal niceties of it. I mean, well, what are you there for? You there to be potted plants? I mean, that's why it's I'm against the what lawyers call the rational basis test. That is, if there's any conceivable reason why a legislature or an executive might put in a given rule, then courts will defer to it rather than putting the onus on the government to justify its restrictions of people's liberty.
So let me ask you the question that I don't know the answer to, and I'm hoping that you do. But we go back and forth. People that believe in limited government, constitutional conservatives, libertarians, and we look at the sort of corruption, inability, unwillingness to do their jobs in all three branches of government. What do we do about it? What's our job to try to get things back in whack?
I mean, civic education. It's tough. At the end of the day, Thomas Jefferson called the Constitution a parchment barrier. There's no Deus ex machina. There's no super guardians that'll step in when the fallible human beings that are running the government are out of whack. There are no, to invoke James Madison's Federalist 51, we're not governed by angels. If men were angels, no government would be necessary. If angels governed men, then we'd have a perfect government to police us, imperfect creatures. But in a system run by men, over men, and women, of course, you first have to check the guardian. You have to empower the guardians to protect our liberties, and then check them when they run amok. And when that breaks down, I mean, if the people don't want to enforce their own protections, there's not much that can be done. And for that reason, I think Jefferson supported having a revolution or at least a new constitution. He wasn't talking about a bloody war all the time, but every generation, every 20 years, 25 years, we recommit to whatever the structural values of the society are. I think we're failing in that.
There was talk about the blood of tyrants, but I think that was just rhetorical flourish. So do some shameless promotion. If we got to get to this point where the citizens who really control whether or not government acts within its limits, it strikes me that all of us need to school up a little bit, and we could be despondent about the public schools and the general unawareness of the constitutional rules of the game. Or we could give people who have an ability to find that stuff for themselves now better tools to do that. And obviously, you've written your new book, and I assume that's available at all appropriate booksellers.
That's right. Whether online or in person, I've actually personally visited all of the Barnes and Nobles in D.C. and Northern Virginia within reasonable driving distance of where I live in Falls Church. I think I hit 13 of them altogether, and signed all the copies there, which means that they count as sales because they can't return them once they're signed by the author. But it's kind of nice. It's basically the only part of a normal authorship process that I've gotten to enjoy, since we can't do these in-person signings or what have you. If your listeners, if your viewers buy it, I'm happy to send a signed book plate that they can stick in there. And it's available, if you listen to books in the car while driving, it's available on Audible or on CD. It's available on your Kindle. You might want to, holidays are coming up. It's a perfect Thanksgiving gift, let alone Christmas and what have you. And I tell you what, Matt, if you go to supremedisorder.com, not only can you find links to buy it, if you don't like Amazon, there's other places, independent booksellers, links there. But for free, you can download a 20-page statistical historical appendix of all the Supreme Court nominations and some of the lower court shenanigans that have gone on the last couple of decades. So you can really nerd out on that and be very popular in your next virtual cocktail party.
Speaking of nerding out, which libertarians are always guilty of, you also oversee an annual review of Supreme Court cases. I think you've been doing this now for 11 years. Talk about that resource as well.
Yeah, the Cato Supreme Court Review, which this coming year, next year, will be its 20th volume. I edited 11 of them, and I've now been publisher for 3. Trevor Burrus, my colleague at Cato, has been the editor for the last couple. And we take the biggest, most significant cases from the previous term from a constitutional and statutory perspective, and commission articles by leading scholars, practitioners, judges, as well as having one article looking ahead. And we try to make them readable. It's hard sometimes with law professors, but our aim is that it's not just an academic tool, but anyone who otherwise consumes Cato or think tank policy analyses will want to learn about the latest decision on whether it's affirmative action or guns or class actions or what have you. And we limit the how long they can be. We limit the number of footnotes. Again, we really try to make this a readable thing. So if you know nothing about what happened in the Supreme Court in the last year, you can learn what you need through picking up this book.
Constitutional lawyers who speak English. I love it. It may be a unicorn, but I'd love to see that.
This is the rule number 1 that I teach my incoming associates. We've had for a while now, I guess about a decade, a legal associates program at Cato. Any law students watching this, if you're going to be graduating, please apply. I think every year the applications are due in February. You come with us for a year, your first year out of law school or after clerking or what have you, and you write amicus briefs, you work on this Cato Supreme Court review, you write op-eds, you help me prepare for speeches and my colleagues as well. It's a great opportunity for young lawyers. But the first thing I teach them is our audience is more than other lawyers, let alone law professors or technocrats. We want even our briefs that go to courts to be read by the media, by potential sponsors, by people wanting to educate themselves. And so write in English. In fact, when I taught legal writing at GW, George Washington University, about a decade ago, I would assign Hemingway short stories, inaugural addresses, articles from Sports Illustrated. Because I said, I can teach you the structure of how to write a brief or a legal memo. That's not hard. What's hard is being a good writer. And so I sent them that. And then finally, they're like, well, can't you give us any examples of legal briefs or memos or what have you? And yeah, I'd send them John Roberts's when he was one of the leading lawyers in the country, a leading Supreme Court advocate. And you know what? What's the difference between a John Roberts brief and kind of a run-of-the-mill appellate brief? They're simpler. Shorter words, shorter sentences, shorter paragraphs. It's not because he's a dummy. It's because he's smart.
Yeah. Okay. Thank you, Ilyas. And I look forward to continuing this conversation as Joe Biden attempts to put a dozen new radical progressives on the Supreme Court.
Yeah. Next year in person, as the toast goes.
Yeah.
Cheers. Thanks for watching Kibbe on Liberty. By now, you know this is the most important event of your week. So make sure you subscribe on YouTube. Click the little bell so you get notifications. Kibbe on Liberty, mostly honest conversations with mostly interesting people.